1968ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်292ဒေါ်အုံးခင် applicant first ဒေါ်အုံးကြည်ဦးဖေသက် respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Revision Before ဦးစိန်သင်း Judge ဒေါ်အုံးခင် Applicant First ဒေါ်အုံးကြည်ဦးဖေသက် Respondents Urban Rent Control Act whether retrospective operation is to be given to a statute so as to impel an existing right or obligation, whether the notification cancelling the operation of Section 19 of the Urban Rent Control Act has retrospective effect. At the time of the institution of the proceeding, standard rent certificate as required by Section 19 of the Urban Rent Control Act are exempt from operation of the Urban Rent Control Act. During the pendency of the proceedings, the exception is cancelled by a notification of the Ministry of Public Works and Housing. A retrospective operation is not to be given to a statute so as to impel an existing right or obligation otherwise than as regard matter of procedure unless that effect cannot be avoided without doing violence to the language of the enactment. Therefore, notification number 185 date the 8th September 1966 of the Ministry of Public Works and Housing cancelling notification number 35 date the 16th February 1951 of Ministry of Finance and Revenue by which the operation of Section 19 of the Urban Rent Control Act had been kept in abeyance does not operate retrospectively. H.S. Haji Ismail Chodani vs. Gobiran Shubhas Rai 1947 RLR page 342 Mashidi Khan vs. B. Mahomed Azim 5 LBR page 148 Mrs. D.M. Singer vs. the Controller of Rents and 3 others 1949 BLR page 143 SC refer to Dai Chuan Company vs. Chen San Chong 1949 BLR page 86 SC distinguished Mr. Archayub for the applicant Ula Singh for the respondents U Sain Thin Judge these are applications in revision against the orders passed by the land for judge of the Rangoon City Civil Court by which he dismissed the applications of the applicant Daw Aung Kin on the ground that they were not accompanied by standard rent certificate as required by Section 90 of the Urban Rent Control Act. The applications were for distress warrants on account of non-payment of rents accrued for the months of January to July 1966 in respect of the premises which was, at the time of the institution of the proceeding, exempt from the operation of the Urban Rent Control Act by virtue of Ministry of Finance and Revenue notification number 35 date the 16th February 1951. During the pendency of the proceeding, the above notification was cancelled by the Ministry of Public Works and Housing, notification number 185, date the 8th September 1966, with the result that the suit premises came to be governed by the Urban Rent Control Act. Accordingly, Section 19, which requires standard rent certificates to be attached to the application for discharge warrants, came into play, and the question arose whether the above notification has retrospective operation, so that the application which were filed before the date of the said notification should be dismissed for want of standard rent certificates. As a general rule, when the law is altered during the pendency of an action, the rights of the parties are decided according to the law as it existed when the action was begun, unless a contrary intention is expressed. Thus, in the case of H.S. Haji Ismail Chodani vs. Gobiran Shubas Rai 1, it was held that Section 11 of the Urban Rent Control Act 1946, corresponding to Section 12 of the present Act, does not apply to a suit for ejectment which was pending when the Act came into force. It was pointed out that Section 11 does not relate to a merely matter of procedure, but that it alters the rights of parties by taking away the lesser right to a decree for adjustment and for recovery or possession of the premises. This ruling seems to be in conflict with the dictum expressed in a bench case of Tai Chuan and Company vs. Chen San Chang 2, where it was pointed out that the provisions of Urban Rent Control Act, which deal largely with the question of relief, are retrospective and apply to pending suit. But in that case, the bench had to deal not with the lesser right of adjustment under Section 11, but with the aspect of law which granted relief to the landlord by enabling him to use Section 11(1)(f) as a she in a case when the tenant applies to have the order of adjustment passed against him discharged or rescinded. Thus, it seems clear to me that the principles followed in both the cases are the same, and there does not seem to be any departure from the strict rule of law that a retrospective operation is not to be given to a statute so as to impair an existing right or obligation otherwise than as regards matter of procedure, unless that effect cannot be avoided without doing violence to the language of the enactment. The present case before me relates to Section 19 of the Urban Rent Control Act, which requires standard rent certificates to be attached to the applications for discharge warrants. The effect of this section is to deny the landlord of his right to obtain rent at the rate agreed upon by the parties. In other words, it deprives him of his right to the rent lawfully due under the law existing at the time when the actions were begun. Thus, it cannot be said that the amendment occasioned by the repeal of Ministry of Finance and Revenue, notification number 35, date the 16th February 1951, is merely as regard matter of procedure. It may, however, be argued that Section 19 does not take away the right of the landlord to obtain rent, but it merely restricts his right by disallowing any sum in excess of the standard rent. But the landlord, under the law as it stood before the amendment, had the right not only to get rent, but to get rent at the contractual rate. It was his substantive right, countenanced by the law in force, when the proceedings were initiated. Even the right of appeal has been held to be a substantive right in the case of APPLICANT vs. B. Mahomet Azim 3, where the following excerpt was quoted. To deprive a suitor in a pending action of an appeal to a superior tribunal which belongs to him as of right is a very different thing from regulating procedure. Surely the right to obtain rent lawfully due cannot be inferior to the right of appeal, and if the latter right is regarded as being substantive in nature, I do not see any reason why the former should not also be regarded otherwise than as such. Some general remark regarding retroactivity of the provision of the Urban Rent Control Act have led to certain confusion. In THET and Company case 2 Supra, it was remarked that the provisions of the Urban Rent Control Act are retrospective, as the Act deals largely with the question of relief. But in the case of Mrs. D.M. Singer versus the Controller of Rents and 3 others 4, the same land judge who delivered judgment in THET and Company case had this to say at page 149 of his judgment. The right to occupy is a substantive right, and Mrs. Singer's right to occupy accrued as alleged by her long before the enactment of the present Urban Rent Control Act. It is a well-settled principle of law that an act never operates retrospectively to affect a substantive right unless the act expressly says so. But the present Urban Rent Control Act does not do so. This clearly demonstrates the fallacy of the statement that just because an enactment deals largely with the question of relief, any amendment made to it, regardless of whether it affects substantive right or not, would always operate retrospectively. To my mind, the correct approach to such a question is to see not only whether the act itself deals largely with question of relief, but also whether the amendment touches a substantive right or whether it only regulates procedure. For all the reasons stated above, it is clear that the land trial judge went wrong in dismissing the applicant's application. His orders are accordingly vacated, and he is directed to proceed with the cases in accordance with law. Under the peculiar circumstances of the case, there will be no order as to the course of this application.